Marites Baynosa sent us an email seeking for advice regarding their access to the main road. According to Marites, her parents were able to buy a 250 square meter property sometime in the 1970s. The property was located in the interior portion of a group of other properties. According to her, there used to be an access towards the main road that was quite wide enough for a whole jeepney to pass through the property fronting the main road. However, sometime in the year 2000, the access to the main road became narrower until it came to a point that only about a meter was left of that access. According to Marites, that access was their only way towards the main road. Recently, they are planning to buy a tricycle, but they do not know where to park the same since it cannot pass through the access road. Marites wants to know if they have the right to demand from the owner of the property fronting the main road to give them an additional meter in the access thereof. Marites, the case of Dichoso versus Marcos, GR number 182282, April 11, 2011, cited Article 649 of the Civil Code, which states in part, the owner or any person who, by virtue of a real right, may cultivate or use any immovable which is surrounded by other immovables pertaining to other persons and without adequate outlet to a public highway is entitled to demand a right-of-way through the neighboring estates after payment of the proper indemnity. Should this easement be established in such a manner that its use may be continuous for all the needs of the dominant estate, establishing a permanent passage, the indemnity shall consist of the value of the land occupied and the amount of the damage caused to the servient estate. To be entitled to an easement of right-of-way, the following requisites must be met. First, the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway. Second, there is payment of proper indemnity. Third, the isolation is not due to the acts of the proprietor of the dominant estate. And fourth, the right-of-way claimed is at the point least prejudicial to the servient estate, and insofar as consistent with this rule, whether the distance from the dominant estate to a public highway may be the shortest. Remember, though, that the well-entrenched doctrine that in order to justify the imposition of an easement of right-of-way, there must be real, not fictitious or artificial necessity for it. Mere convenience for the dominant estate is not what is required by law as the basis of setting up a compulsory easement, even in the face of necessity. If it can be satisfied without imposing the easement, the same should not be imposed. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno Atienza for the Rule of Law.